everyone. My name's Maggie Forrest. I'm one of the reference librarians at the Troy Public Library. And tonight's Zoom presentation will feature advisor Ken Bloom from Bloom Advisors. Ken is a partner, an attorney, and a financial advisor at Bloom Advisors in Farmington, Michigan. And he's done many presentations at the Troy Library in the past. So we welcome him back tonight. Now, what we're going to do, the way we're going to run the program tonight is Ken will do his presentation, and then at the end, we will have the Q&A. You put your questions down in the Q&A or the chat, and I'll come back on, and then I'll state the questions to Ken. But tonight's presentation is about estate planning, which can be really complex. And Ken is going to talk to us about some of the different legal documents and how you can really take care of your family, and maybe some scenarios that come into play with families. So Ken, thank you again. And again, put your questions down at the bottom, and at the end of the program, we'll go over those questions. Thanks a lot, Ken.
Thank you, Maggie. Welcome, everyone. I am going to share my screen in just a minute. I just wanted to thank everyone for participating this evening, give you a little, excuse me, talk a little bit about the format for today. I hopefully to talk for about 45 minutes, and then at about 6:40, and then afterwards, open it up for questions. As Maggie said, please send all of your questions to her via the Q&A feature, and hope to be able to have enough time to answer all your questions. If by chance I don't, or if I don't know the answer, please feel free to email me, and I will do the best I can to answer your questions. I want to thank the library for hosting me today. As Maggie said, we being myself and other people from my office, my brother, Scott, seminars for years and years, and we really appreciate the opportunity, and we look forward to doing them in person when COVID isn't at the top of our lists. And hopefully next year at this time, we will be laughing about COVID and everything that we went through to survive. So with that, let me just start sharing my screen, and welcome again. Okay, so, okay. So here we are. 1 second, let me just do one other thing. Okay, great. So a lot of times when we talk to people about having an estate plan, the one question that comes up constantly is, what is an estate plan? And there are people out there who believe that unless they have a lot of money, they are unable to have an estate plan because only the rich have an estate plan. And nothing could be further from the truth. The most important thing when it comes to an estate plan is actually planning. And I believe not everyone needs to have a trust. We'll talk about trust in a little bit. People seem to think that lawyers only want people to set up estate plan trust because lawyers can make a lot of money that way. I believe, and I'm a lawyer, that trusts for many people are a very important tool and maybe needed and recommended, but not necessarily for everyone. So the starting point for me as what is an estate plan is it's a thoughtful plan for distributing assets following death. Now, I happen to be by nature an optimist. And to me, the glass is always half full, and I'm always looking forward to better things. However, whenever we talk to anyone about estate planning, I tell them we have to make one unfortunate assumption. That assumption is we are leaving this earth sooner than later. I do it not to scare people, not to intimidate them, but it's really important to put yourself in that mindset, because if you think you're going to, you know, for a fact that you are going to be around for another 5, 10, 15, 20 years, then you can wait another 5, 10, 15, 20 years to develop your estate plan. But as we all know, life doesn't work that way. We all know people pre-COVID, maybe even during the COVID, who one day were here and then the next was gone. And there are a lot of very famous people who, when they die, I'm always stunned that they don't have an estate plan. Okay, we're reading in the paper about what happened with Aretha Franklin's estate. It's a complete mess. And so one of the objectives of having a thoughtful estate plan is to minimize the delay to family, to minimize costs, and to make it as simple as possible, so that the beneficiaries you select receive your money following your death. That is it. That is it. So as uncomfortable and unpleasant as it may seem, when you're thinking about your estate plan, you have to assume that your time is going to be up in the very near future. Okay. I start this slide about taxes for one very simple reason. 99% of you will never have to worry about estate tax. And it's always a question that comes up, that people are worried about taxes following their death, and it prompts them to take certain actions because they think they're going to avoid paying tax. The reality is there is no tax following death. We have a system that at death, the net fair market value of everything someone owns is tabulated. In 2021, if the value of those assets exceed or less than $11.5 million per person, there is no estate tax. Let me repeat that. In order to have an estate tax issue this year, the net fair market value of all the assets you own at the time of your death have to exceed $11.58 million. Now, a little way of background, and I'll try to make this as simple as possible. The amount now is a temporary amount. It was a byproduct of what is referred to as the Trump tax changes. In 2026, I think, or 2027, forget the exact year, this number is going to revert back to the old number, which was set during the Obama years. And that exemption was originally $5 million indexed for inflation. The 11.58 was doubling of the Obama exemptions. So if it went back to the Obama exemptions right now, it would be half of 11.5. So a little less than 6 million. So if nothing happens, the law reverts back, it would be approximately $6 million a person. You married, you double it. I've been doing taxes for a long time. And the one constant, when you talk about estate planning, you always say, one of the constants is death. And in tax planning, we all know that another constant are taxes. What we do know is taxes will change. They always do. What is unknown is how and when the changes will occur. I believe that trying to speculate where taxes will be 5 years, 10 years down the road and longer is a fool's game. We have no idea. 14 months ago, whoever heard the term COVID, whoever thought we would be doing Zoom set webinars, okay? Things change. I don't know how they'll change. So until I have guidance or a pretty good idea what's going to happen, I base all my tax planning strategies, income tax and estate tax, on what the law is today. Okay. So right now we know the exemption is over $11.5 million a person. Married, you double it. That is also the case under what was in place during the Obama administration. There are a few taxes that come into play if your estate is under the exemption amount, but those taxes are income tax, not estate tax. When someone inherits money following death, with minor exceptions, the beneficiaries do not have to pay tax. If there is a tax, it is paid by the estate. One exception deals, as I said, on the income tax on IRAs, retirement accounts. When someone inherits an IRA, so what happens is someone's Aunt Mary died, had an IRA of $150,000, left that IRA to her 3 nephews and nieces. Gets divided up in thirds, so each nephew and niece would receive $50,000 of the IRA. The inheritance of the IRA is not taxable. When the money is paid out, there is income tax to be paid. One big difference between an inherited IRA and a regular IRA is that when you inherit an IRA, you are required to take minimum required distributions over your life expectancy, regardless of your age. With a regular IRA, you are required to take distributions, except for Roth IRAs, when you turn 72. Used to be age 70 and a half. It is now age 72. With an inherited IRA, you do not have the ability to take it out at age 72. As a matter of fact, there's a change that went into effect in late 2019. When you inherit an IRA now, other than a spouse, the beneficiaries have to take out that money within 10 years. They no longer can take the distribution over their life expectancy. It's 10 years. They can take it out in a lump sum. They can take it out in year 1. They can take it out year 10. They could take it out a little bit here and a little bit there, but they have to take it out within 10 years. And when the money is taken out, they pay tax on the money, income tax. With respect to non-retirement assets, there is no tax to the estate. There is no tax to the beneficiary on inheriting those assets. As a matter of fact, there is what is called a basis step up. So if someone dies and they had a piece of real estate that they paid $250,000 for, and at death it was worth $600,000, The beneficiaries, when they acquire that property, have a new tax basis of $600,000. That means they could sell that asset and pay no tax. If the day before person died, they sold that real estate and their basis was 250, they sold it for $6, they'd have $350,000 of capital gain. Okay, so taxes generally for people are not an issue in setting up their estate plan. If you do, then there's some other strategies that we could talk about. But for most people, taxes and estate planning are a non-issue. Okay, what are the elements of a good estate plan? Well, here they are: will, trust, durable power of attorney, medical power of attorney, and maybe some special assets. Now, following death, who inherits your assets? So for most people, they own their assets one of a couple ways. With regards to, say, retirement accounts and other, they have what is referred as beneficiaries. Anyone who has an IRA has a beneficiary. If you have an insurance policy, there's a beneficiary, an annuity. Some investment accounts, some bank accounts could very well have beneficiaries. Sometimes they're referred to as transfer on death. If you have an account that has a beneficiary, then as long as those beneficiaries are alive at the time of your death, they acquire those assets by operation of law, regardless if you have any other documents, a will, a trust, or nothing. So people who have an IRA and list their children as the beneficiary, children get it following death. Same with investment accounts or anything else. Some assets are owned as joint tenants with rights of survivorship. Most common one is a house. It could be a bank account. Rule here is very simple. If you own assets jointly, rights of survivorship, as long as the survivor is alive, they own the asset following death, and you do not have to do anything. You don't have to record anything. You don't have to do anything. The asset becomes owned by that joint owner. Depending upon how the account is, if it's an investment account, a bank account, you may have to update the Social Security number, but there is nothing otherwise that have to be done. What happens if you have assets that are owned by a trust? Those will be distributed in accordance with the terms of the trust. What if you own assets that are in your name, not in the name of a trust? There is no beneficiary. It's not jointly held. What happens in that case? Well, in that case, those assets are subject to probate. And probate is, in my experience, greatly misunderstood. What probate is at its core is the legal process by which property is transferred from someone who is deceased to someone who is alive. That's what it is. And it applies to whenever you own assets solely in your own name at the time of your death that does not have a beneficiary or a joint owner. So let's imagine a couple of different scenarios. IRA. Beneficiaries are children are alive, but following death, they get the assets. The IRA, very simple. Bank account owned jointly, husband and wife. Upon death of one, goes to the other. Same with the house. There is this couple, My favorite fictional couple is Archie and Edith. And Archie, at the time of his death, had bought some, or while he was alive, got a tip from someone, and he bought a few shares of a company that had just started out named Apple. And at the time of his death, he had accumulated $100,000 of Apple stock. What happens to the Apple stock? It was owned solely by Archie. Doesn't matter that he was married to Edith for 50 years, 60 years. It's an asset owned by him solely in his own name. So now, in order to transfer that asset, it will be necessary to open a probate. But what if Archie had a will? What if Archie's will said, all my assets to Edith at my death? Would that avoid probate? The answer is no. But a will serves as directions to a probate court. Who's to get the asset? Since Archie owned the asset solely in his own name, there was no beneficiary, there was no joint ownership, it would require the opening of a probate. In general, always subject to exceptions, probate is something that we generally want to avoid. Again, now there are exceptions. And the reason that I want to avoid probate, the way I recommend people, if they can avoid probate, very simple. Number one, since probate is a court proceeding, you inevitably are going to have to hire an attorney. And so you'll have attorney fees, filing fees, and various court costs. That's number one. Since it is a court proceeding, it is public and could very well, and because it is a court proceeding, it becomes more time consuming. Oftentimes you find that someone's will may very well have some issues, or maybe some, so look what's happening with Aretha Franklin. So you had multiple wills, and they were all inconsistent. So now there's a big court fight going on as to who acquires what. A will, a lot of times people will say to me, well, I got a will, it's really old, so therefore it doesn't count or it's obsolete. Wrong. A will that was validly signed remains in effect until such time as it is either revoked or amended. A will is revoked by executing a new will, replaces it. The first line of all wills say, you hereby revoke any prior wills. Okay. So if you have an old will, people do this all the time. They signed the will 30 years ago, 40 years ago. Maybe they had provisions for 2 kids, and now they have 3 or 4. They name people in there to manage the estate that no longer are alive, or maybe they don't have relationships with, or there's other things. Doesn't matter. If it still remains valid until it is replaced. What about if someone dies and doesn't have a will? What if Archie never executed a will? Okay, back for a moment. So what happens there is, in that circumstance, Archie would be deemed to have died intestate. Intestate's the legal term for someone dying without a will. And what happened, every state has its own intestate rules. And what it says is how the money is allocated between family members. And people sometimes assume that, oh, well, that all the assets would go to The spouse, no. About 10, no, it's probably about 12 or 14 years ago. New client. And I was doing some business work for him. And then he subsequently, shortly thereafter, died in an auto accident. And it turned out that he did not have a will, did not have a trust. It was something we had just talked about. And he had an estate that was in his name. I think back then it was like $8 to $10 million. And that's the good news. The bad news was, again, there was no will, had to be probated. And because it was intestate, the Michigan law said after a certain amount, the estate got split between wife and children. Well, his kids were 18 and 20. So can you imagine? Here it was that an 18-year-old is going to get $1 million or $2 million unrestricted. So, people say, well, that was silly. Well, maybe. Well, what could he have done? Well, he could have set up his own estate plan. So the provisions of the intestate laws are mandatory. And the only way they're avoided is by setting up your own documents. Okay? All right, so what is a will? A will is nothing more than a written document executed with certain formalities that says who's going to own your assets following death. That's it. I always tell people, do whatever you want with your money. It's your money, and certainly not for me to tell you what to do with your money. In Michigan, we do not use the term executor anymore. We use the term is called personal representative. That's a person who oversees the probate and distributes the assets in accordance with the terms of the will. Okay. And however you want to name the beneficiaries, whatever. And depending upon how complex the probate is, it can, on the short end, it's 3 to 6 months, maybe 4 to 6 months for a probate. And it could last for years. And usually, if it lasts for years, many times that has nothing to do with having large estate. It just, you may have assets in multiple states. You may have beneficiaries all over. You may have assets that are owned that aren't simple to liquidate. And keep in mind, probate is varies from state to state. So if someone owns real estate in Michigan and owns real estate in another state, Florida, then you're going to have a probate in both Florida and Michigan. And as I said, a will does not avoid probate. Okay. Now, people may very well be may not have a lot of assets that would be subject to probate. And so maybe having a simple will is all they need. We have on our website, which is either bloomadvisors.com or the law firm, bloomlawfirm.com, what's called the Michigan Statutory Will. It is a free, I repeat, free fill-in-the-blank will. Download it, follow the instructions, sign it, have it witnessed, and you have a completely valid will. People say, well, maybe I'll search online and do it. Well, problem is when you search online for wills and things, documents, and you don't know who prepared them. You don't know if they comply with Michigan law or anything else. So if you got a free will, the statutory will is something that's been blessed by the Michigan Bar Association and the Michigan Supreme Court. And so it's valid for people who have relatively simple estate needs. Highly recommend doing the statutory will. There is one time where a will is absolutely essential. And to me, this is the most important thing. And that is if you have a children who are minors, then the only way, then the will allow you as the parent to designate who you want to be guardian for the children following your death. Let me repeat that. The only way a parent can have a voice as to who is going to be selected guardian for their children is through a will. If a parent dies, parents die, and there is no will, or the probate court will determine who has custody and who has guardianship. Doesn't matter if you've agreed amongst yourselves. That ultimately is up to a judge. And even if you have a will, the judge could very well do something different. It's unlikely. But the way the law is that they will give great weight to the wishes of the parents. And the way the parents convey their wishes is through execution of the will. What is a trust? Trust is really a document to own assets. That's all it is. And the trust that most people have and possibly need, and what we're talking about, it's called the revocable living trust. It means it goes into effect while you're alive, and it is revocable. With a trust, that there's a beneficiary and there is a trustee. The trustee is the one who administers the trust for the benefit of the beneficiaries. Okay? The trust lays out the terms by which the trustee will distribute the assets to the beneficiary. Sorry, I need a little sip of water. Okay. The typical case, Archie and Edith set up a trust. And Archie and Edith are the trustees and the beneficiaries. They do what they want, however they want, as long as they're capable and as long as they're alive. They determine who will succeed them as beneficiary and who will succeed them as trustee. In Archie's case and Edith, they had one child, Gloria. And what they would do is no reason for them not to appoint Gloria as a successor trustee and then say that she would be the beneficiary. Now, as long as the trust owns the assets or the assets are the beneficiary of the accounts, then there's no probate following Archie and Edith's death. Following Archie's death, Edith is in control. She is the trustee. She is the beneficiary. When we set up the trust, we always have to think about the unthinkables. What happens if Gloria were to predecease? So we have a provision. And some of you may not remember, but Gloria had one son, name was Joey. So the trust would provide that in the event that something happened to Gloria, then, or she was not alive, then the beneficiary would flow to her children. I get asked all the time. We just had a conversation with someone a day or two ago. What about husband, in-laws, son-in-law? Do they get to share the money? And generally the rule is money follows blood. So unless Gloria said something otherwise, the money would go to Gloria. And so by doing it this way, you're making sure that the assets aren't subject to probate, keeping everything private. The estate can be distributed very quickly. And there are some other benefits with having a trust. To me, avoiding probate is a very significant advantage. Another advantage is, let's assume, it is something that totally different. And that is the trust allows you to control how and when money is spent. Okay. So back to my example. If at the time doing their estate plan, and the examples I'm going to give you are sort of based on some real life experiences I've had. Archie and Edith were concerned that Gloria's husband exerted too much control over Gloria, and they didn't want him to get access to the money. And so the trust we could set parameters so that the money basically remains in trust and is paid out over time, or paid out for certain conditions or for certain items. So, because once the money's paid out, if the money becomes commingled or otherwise, then the money could be used in ways they wouldn't want. What if Gloria's husband or Gloria had some tax problems? Or what if Gloria had a dependency problem? So by the trust would allow us to keep the money away from her and not pay it out to her to be used for, again, if she had a dependency issue, she had tax reliability issues. What if what if the marriage was rocky and they wanted to protect the assets that way? So there's a multitude of ways. What we can do is to keep the money sheltered, basically in trust, to protect the beneficiaries. Very common when you have children or as beneficiaries, if they're of young age, then what I generally do is, instead of giving the money to the kids when they are 18, 19, pay it out over time. Money can be used to help pay for college and other things, but you don't want to pay it out to them before they are mature and sophisticated enough to handle the money. I've used the trust as to incentivize people. So a client was worried that his children would not want to work, would become fat and lazy, so to speak. So we put provisions in the trust that the trust would pay out money to the children if they had a job, if they made certain, and it was basically matching their W-2 or things like this. So it incentivized them to work. While the money's in the trust, it is free. It can't be attacked by creditors of the kids. So there's a protection there as well. So since recently, more and more of the trusts I'm doing are used for this purpose, to control how the assets are being spent. Okay? It's also used to avoid probate. There's no question. One other benefit of a trust, it deals with special needs. So people who are disabled, receiving benefits from our needs-based benefits, it's really important that if the assets are paid out to them, that what would happen is could end up losing the benefit of those needs-based benefits. So rather than that, the trust is used to hold the assets. It pays it out in such a manner that it doesn't disqualify the beneficiary from continuing to receive needs-based benefits. It also is helpful when you have someone who may very well be not able to handle their own affairs. Again, I had a situation where a very good friend of mine did his estate plan a number of years ago, and he was helping with his wife, his mother, excuse me. And he wanted to leave her money from his estate in the event that he, predeceased. And I urged him not to. I said, let's leave it in trust. We carved out a provision that money would be set aside in trust rather than pay out to her directly. Why? Well, number one, again, if she received need-based, but I was also worried about it. What if the money was paid out to his mom and his mom became diagnosed with dementia or something? Then there would be no protection. But keeping it in the trust, the money could be paid out for her benefit. Could be, we set out these parameters so that even if she became unable to make sound decisions because of Alzheimer's or dementia, the money would be protected. So those are the number one reasons today that we set up a trust. A couple quick other items before I open up for questions. I think all estate plans require a durable power of attorney. A durable power of attorney allows you to act on behalf of someone else. And it is a very broad instrument, but it allows someone to act on your behalf. And especially in this day and age with all the other restrictions we're getting because of all the fraud that comes out with an internet and banks are becoming more and more restrictive. You can't walk into a bank and say, oh, my dad has an account here. I want the information. Okay. You're not going to get it. So powers of attorney allows you to appoint someone to act on your behalf. If you're worried about who that person you're giving, you're worried about your child or whatever, there are some protections that can be built in. You can name multiple people to have power of attorney. Remember that the power of attorney says they have to act for your benefit, not their benefit. Medical power of attorney. Now, medical power of attorney is a little different because it only goes into effect when you are incapacitated. So what happens is, whereas the general durable power of attorney goes into effect immediately, the medical does not. Michigan law says that as long as you are able to, you can make your own medical decisions. And in the event you cannot, then you can appoint someone to make those decisions. So if Edith went into a hospital because she needed to have a procedure, what happens is Archie has the power of attorney to make medical decisions for her. And in the light of HIPAA, this becomes very, very important to have a power of attorney, because HIPAA basically says that without it, doctors, medical professionals, hospitals are not supposed to divulge any medical information to anyone else. The good news is that you can have multiple medical powers of attorney when you go into a hospital. The second for any procedure, what they're going to do is see if you have a power of attorney on record with them. And if not, they'll have you sign a new one. There's no harm in having multiple ones signed. Lastly, we put on here special assets. And the ones I want to highlight here are digital assets for a minute and homes. So with regard to your house, for years and years and years, the way things were done, whereas if you had people with modest means, they would, or assets, not a lot of assets that would be subject to probate, they would do a deed. It was called a quit claim deed. It was signed, put away, and then following death, the deed was recorded, and that would be a way of avoiding probate on transfer of assets. We did that with my grandmother. Today, for multiple reasons, that process is no longer used. It is replaced by something that is called a Lady Bird deed or an enhanced life estate. And basically, the difference is the deed says that the house remains your house, do whatever you want as long as you live. And at death, then it goes to whomever is our names, beneficiaries. The other significant difference is that the deed is recorded now. With a quitclaim deed, what was happening, the house was transferred to, say, the children now, and since someone was living in the house, they didn't want that to happen. It was recorded following death. With the Lady Bird deed, the language says the house is yours as long as you are alive. It allows you to sell the house. You could terminate it, do whatever you want, but the asset is only transferred following death. The last one that is really important this day and age deals with digital assets. And that is everything from passwords to email, iTunes accounts, Facebook, et cetera, et cetera. And what ends up happening, unless you think about it and have something prepared, following death, none of these agencies, none of these companies are going to disclose that password. And there may very well be some very important information. So as part of our estate planning bundle, we have a specific power of attorney and specific designation dealing with digital assets. Well, all that COVID has done is made us look at life a lot differently. And by this, I mean, I think we've all started appreciating various things. So when is a good time to start thinking about an estate plan? Well, to me, if you don't have something, or you haven't thought about it, or if it's very old, the time to do it is now. Don't put it off, because we don't know if it'll be too late, if something's going to happen to us all. And with that, I'm going to open it up for questions. I want to thank everyone, and I hope it was interesting. So, and that you may have learned something. So let me figure out, stop screen share. Maggie?
Okay, first one, person says, so if I understand it, the best way to avoid problems is to name beneficiaries on all your assets, and therefore it will not go through probate. And also you do not need trusts or wills.
Short answer is, if all your assets had a beneficiary, you would not need a trust or a will to avoid probate. However, naming a beneficiary, isn't a perfect solution for a lot of people. So for instance, again, I mentioned if you needed to control how the assets were spent. I had a woman who called me up, a new client, and she wanted to leave money to her daughter, but she wanted to dictate how her daughter was going to spend the money. Okay. And I had to explain to her, if the daughter's the beneficiary of the account, when she inherits it, she can do whatever she wants. No restrictions. She's not limited by mom's instructions. Okay. So if you're to answer the narrow question, will it avoid probate, and will it the answer is yes. And so that's what I would say.
Okay. And next question, what if the deceased owns a home, but the home title is not found? What would happen in that situation?
Well, I think they're referring to what if the deed isn't found.
Yes.
Okay. So what happens is, in 99.99% of the time, ownership is determined by the deed is recorded with the Register of Deeds office. So if I try to sell my house here, and I can't find my original deed, it doesn't really matter. When I got ready to sell my house, the title, there's going to be a title company, and their job is to look and make sure that title is properly vested. So the title company checks the record with the Register of Deeds, and they see how the house is owned. It doesn't matter. I don't need an original deed to prove it once it's recorded. Okay. That's why recording is so important, because with real estate, with personal property, the old saying, possession's 9/10 of the law. Okay. So I have this ring here. So how do you know I own the ring? Well, it's on me. Okay. But with real estate, it's not so simple. So we determine who owns real estate. The process is recording the deed. A deed is nothing more than a bill of sale. When you buy a house, you record it. And once it's recorded, it becomes a permanent record. So if you don't have a copy of your deed or have a copy of your title policy, it doesn't matter. Because once it's recorded, that's all that matters.
Okay, next question. What kind of paperwork do you need to show JTWROS when you pay your house off?
Okay. So if you have a house, husband and wife, deed, when you bought the house, the deed was either said Archie and Edith, joint tenants with rights of survivorship, or Archie and Edith, husband and wife, or tenancy by the entirety. It's all the same. Now, so if the deed is in the name of, in that fashion, and you're paying off the mortgage, what will happen is the mortgage company, when it's paid off, is required to send you a discharge of mortgage. And they'll say, okay, Archie and Edith, what, they paid off the mortgage, they record a discharge with the Register of Deeds.
Okay. Is the medical POA same as patient advocate designation?
Yes. I use the term medical power of attorney because I think it's more easily understandable by people.
How frequently should you update each of these documents?
So I think people should review their documents every 5 years. Okay. Think backwards for a moment. Go back 2016. For most people, their health was different. Maybe they were married, maybe they weren't, maybe they, most people, maybe they had more money or less money, whatever. Things have changed in 5 years. And most people, at least in our office, who have most clients, they don't need to update their trusts every 5 years. I just want them to look at it and say, hey, I've named so-and-so as trustee. is that still the persons I want to be the trustee? Have there been any other changes? Maybe you have new grandchildren that you didn't include. Maybe you made provisions for someone who's no longer alive. So if you just look at it at least every 5 years, I think that's at a minimum what people should do.
Next question. What is the cost of estate planning without a trust?
Without a trust, well, it's kind of hard for me to answer because I just told people how they can do a simple will free. so at least if they want some powers of attorney in addition to it, I'm guessing $250 to $500. Just a ballpark. Say $500 for the powers of attorney, better yet.
Okay. If I leave my money to a charity, how will they know if I am dead if I don't have remaining relatives to execute it?
Well, what ends up happening for most people, it's your personal representative who oversees the entire process. So they would notify the charities of the bequest. If there are, so ultimately, I did a speech once on basically the topic is, when do you tell people about your stuff, or how do you go about doing it? There's no right and there's no wrong. For most people, if they want to at least let somebody know where the documents are, okay, following death. So if they don't have an extended family or a large family, because otherwise, ultimately, it'll be found out. It'll just take a long time. So in those circumstances, you just want to let someone know, hey, the documents are with so-and-so, either the attorney or they're here or there or whatever.
Let's see. Do you think there's a good chance that beneficiaries will have to begin paying on basis in the future? In other words, will basis go away?
No, I think what they're referring to right now, there's what's called a stepped up basis. I mentioned that earlier. So if you bought an investment for $10,000, and at the time of death, the investment was worth $25,000, the tax basis went from $10,000 to $25,000 following death. Okay. There have been talks periodically of doing away with that. Okay. I have no way of knowing whether or not anything like that would happen. Okay. There are a lot of policy considerations. There's a lot of benefits to keeping it. As I said, I would base it what the law is today. The law today says there is a basis step up.
Next question. Do you recommend one or two trusts for married couples?
Yes, no, maybe, sometimes. So it all depends on the specific nature. If there is a second marriage, then for sure, then generally recommended a separate trusts. Many cases, if just a single marriage, depending on the amount of assets, I generally will recommend a joint trust. I've had people worried about that in the event of death, the surviving spouse may do something with the money, marry someone else, whatever. In that case, that's a reason to consider a separate trust. So it really is a case-by-case analysis.
What is the reasonable amount to pay a personal representative to execute a will who is out of state, includes sale of the house, etc.?
It'll vary. Generally, it's going to be an hourly rate. It just because it varies from probate to probate. It depends how much money is involved, where the assets are. So I can't give an answer on that.
I have a money market bank account that will not accept a trust, just a beneficiary. What can I do if I really want all the funds to go into the trust?
One of two things. One, you could probably set it up with the bank as a transfer on death to the trust. And if that won't work, you're just going to have to change banks. So for, go to Fidelity, Vanguard, something like that, and open the account there.
If the ownership of the house was in the names of the husband, wife, and their adult children, would they have to go through probate after the parent's death?
No, but I would strongly recommend that the house not be in the name of the parents and the children. And so I'll give you just one simple reason. If the house is in all their names and one of the children has a lien against them, gets sued, um, divorced, it will impact the house, period. And a house that's owned by a husband and wife is entitled to certain liability protection, can only be subject to claims of a joint creditor. But if the house is owned by all of them, they've lost that joint protection. So not a good idea at all.
Next question. Can you take a digital power of attorney to Apple to unlock a phone or an iPad, etc.?
I don't know the answer to that.
That's why you have to have a roadmap and put
Yeah,
all.
I honestly don't. I think you should be able to, but I just don't know for sure.
Where does one obtain a ladybird deed?
Well, so a deed is a legal document. So generally lawyers prepare it. Depending if you have a relationship, sometimes you can get a real estate agent to prepare it or a title company. That's
Okay. Does the signature need to be notarized on a simple will in Michigan?
yes.
Okay. If you have a small estate under 450,000, what should a trust cost? I have a home in Michigan and Florida. Both are paid in full.
Okay.
IRA is already set up for the children.
Okay. So for many people, most people, setting up the trust isn't the cost isn't based upon whether you have 450,000 or 4 million. Okay, it's the work is the same. Okay. Now there are always exceptions to that. And in my office, if I can, what we do is we sit, there's no charge to have a meeting on your estate plan, and we get some more information, and then we can give you an idea exactly what the fee would be. You want a ballpark $2,500 to $3,000, okay, for the trust and all the associated documents. Okay, it can vary, it just vary, but so until I know more specific information, I can't say.
Okay, we have a comment. By the way, this was very informative, and thank both you and TPL for this. So that was neat.
Thank you.
Okay, couple more questions. I apologize for being late. Is this being recorded? Will that recording be shared with participants? They have allowed us to record this. And so probably maybe in a month or so, it'll be on our virtual archives on our website under the adult tab. We're still waiting for 2 other ones to be edited. They have to edit them. So yes. Let's see, what's another one? Thanks again. This was informative. Do we have any other questions for Ken?
Well, then I just want to say thank everyone. Um, and like I said, I hope to see everyone in person and be safe. These are crazy times. And honestly, if you haven't started an estate plan, please do so. And if we're able to help you, we'd like to. There are a lot of people out there who can help you. So very important that you take care of it.
Okay. One other last question. Does the trust file taxes?
While you're alive, the trust reports all the income on your social security number. And so that's no different. Following death, until the assets are ultimately distributed, the trust has to file a return. But as would the estate if there was no trust.
All right. Well, thanks again, Ken, and we really appreciate the seminars from Bloom Advisors. Again, it's bloomadvisors.com, and you can Google it if you're interested in finding out more information from Bloom Advisors. And thanks again, everyone, and stay safe, and check our calendar out for other programs that we'll be having soon. All righty.
Thank you. Good night.
Thank you.